because of the fact that the ICJ cannot implement orders, is the primary relief being sought by South Africa in the application, the first relief being sought, that the state of Israel immediately suspend its military operations in and against Gaza. You predicted that wouldn't happen in any event. But my issue is that because of the fact that this eventually has to go to the United Nations Security Council, and in the inevitability of a provisional ruling, they would simply veto it. I mean, does the ICJ not have that particular power in order to grant it relief?
It has that power, and it acted on it in a very bizarre way. I don't want to go into details. It acted on it with Ukraine and Russia, but I don't want to go into the details. In general, it has not called for a cessation of military activities. It has not. My colleague Muin Rabbani has read through the old cases. I have not read through all of them.
Should it not have done that? I mean, from a principle point of view,
I didn't think it was possible for the very simple reason that because Hamas wasn't before the court, it would have been a one-sided, a unilateral calling for cessation of hostilities. It couldn't have been mutual because the court didn't have the power to make it mutual, because Hamas is not a state and it's not before.
Well, what was the difference between the Ukraine and the Russia? Was that because there were allegations?
The Ukraine was so convoluted and so bizarre. It was completely ridiculous and it was completely political. And we all know that that's how the courts operate 99% of the time. Surprisingly, in the case of Palestine, it didn't, I have to say. I thought it was this thing was dead in the water. I was totally shocked by the vote. Though I have to say, not that I keep score, I claim now that I was half wrong on the American judge. I said there's no possibility in the world that she's going to vote that Israel was plausibly committing genocide. Well, she did, but guess what? She then took it back. So I think I get half a point. I don't get a goal, but I get something out of that. Now, if we turn, I have to watch the time. If we turn to what happened in the past week, formally speaking, you could say it's a tie, because South Africa claimed that there is a imminent irreparable harm being done because of the starvation. Israel claims that's not the case, but there's a very big difference, a huge difference. And here is the difference. The difference is South Africa quoted UN authorities. It didn't quote its own government. It quoted international humanitarian organizations and it quoted UN organizations. What did Israel quote? The second person who came up, I guess her name was Torkeman. The second person who came up, all she did was quote generals, Israeli generals and Israeli officials.
Yeah.
So you cannot reasonably say that what's called in law evidence with interest, namely quoting your own government saying, hey, we aren't doing this, with evidence against interest, namely this was UN officials, have no dog in this race, UN officials, Secretary General, head of World Health Organization, head of World Food Program, Undersecretary for Humanitarian Affairs. They have no dog in the race. And they're saying that a mass starvation is imminent. So at that level, even though formally it's statement versus statement, in reality, it's statements with interest versus statements without interest. So you can't compare the two, in my opinion.
In fact, we South African case, and I'm not praising our government, but we did an 85-page application with about 500 footnotes.
Yeah, with all UN sources.
Israel didn't produce a written document. They argued from the bar, so we don't have a written document.
They did produce one, but it hasn't been publicly made available. They had this. You will recall they always refer to, if you look at tab 1, if you look at tab 2, if you look at tab 3, they're referring to a document that was submitted to the court, but for reasons I don't know, it hasn't been made public.